advocate and top 3 in 13th SC Javeli Memorial National Moot Court Competition 2011. She has a participation in 12 national moot courts and has been training students for moot court since 2011. We welcome you, ma'am, for today's workshop, and now I request Dr. Pragnya S. Patil, ma'am, to commence the webinar.
Thank you so much, Shambhavi, for the sweet introduction. Hello, everyone. Good evening. I'm Dr. Pragnya Patil, as Shambhavi has already introduced me. And I would like to say that my moot court memories that I have from my BLLB honors undergraduation studies are the most cherished memories, I'd say, from my college days. I've really enjoyed mooting, and I hope that as mooters, you too will have maximum fun and learning experience through mooting. Yeah, with this, I'd like to begin today's small introductory moot court session. Yeah, shall we begin? Okay, so as a law student, we are studying a lot of legal concepts. We're studying a lot of legislations, theoretical subjects, right? But we have to understand that though academics is very important as a like a foundation, right? At the same time, the practical knowledge is equally important, right? That is why we have clinical courses, right? So to train the law students, to equip them with this practical knowledge, we have a lot of such simulation exercises designed for the law students, right? Apart from the internship, the court visits, we also have stage-wise training. Like initially, if you imagine that you're sitting in your office, then what happens? The client comes in. So how do you have to interact with your client, right? That is client counseling, client interview, then the client pre-trial preparations, and then in the trial stage, the mock trials will help you understand the trial stage. Then comes the moot courts, and then how to write a judgment. So for this, we have the judgment writing competitions. Right? So what is a moot court? By now, because you have already registered yourself as as participants in this moot court competition, so I'm sure you know the basics of moot court. But still, I would like to give you a brief introduction to moot courts. Right? It is a simulation exercise, right? It is a courtroom scenario which is introduced to a law student. Usually, it is a apex court proceeding. Okay, it is an argument stage. All right. So, an imaginary case is given to the teams, and the teams prepare for the argument on both the sides, both for and against. Okay, so this basically helps us bridge the gap between the theory and the practice, right? So, the moot court is not just about arguments, it is much more than that. Right? So, what is it? So, as part of moot court, you are not only arguing, but before that, you do a lot of research. You learn professionalism. You learn courtroom etiquettes, How do you behave in a courtroom? How do you place your argument? Do you just barge in and then just start, just like in the movies, they show, just ruko, main aa raha hu, and then they'll bring their evidence. Is it like that? No. How do you have to behave in a courtroom situation, in a courtroom, right? So all these are very important, right? So uh, to introduce you to the courtroom situation, we have moot courts. So we have a fictional case called a moot problem. So what is a moot problem? So it is a imaginary legal case with multiple legal disputes, or we call it as moot points. Okay. It mirrors the realistic challenges that we find from various laws, the real life scenarios, and then it encourages the participants to identify the legal issues, then interpret the ambiguities in it, apply the principles of law, the precedents, okay, then argue in support of his or her client. Very importantly, when you're before the judge, you are convincing the bench. Okay, that is very important. You should always remember as a mooter that you are convincing the judge. Okay, a moot problem is crafted with a neutral tone. Okay, so that it is balanced, so that both the parties can argue fairly. Okay, it is like an unsolved legal puzzle. Okay, very interesting because it involves the mooter digging into the depth of the subject. Okay, as a mooter, when see I started mooting when I was in my first semester. So see, by the time you complete your moot court journey, I mean for that particular moot court, you would have understood the depths of the subject. Okay, thorough in detail. Whereas if you listen to the same in the classroom, I would definitely say that classroom education is very important. But see, as I say, if you teach, you're learning. But you involve the students, then yeah, you give them responsibilities, they get involved, so they understand the details, the intricacies of the subject. So the clinical course or the moot court helps us in building that analytical ability, research skill of the student. So some people say that it is just very much similar, it is a combination of essay writing and debate. No, it's not. It is much more than that. In debate, it's different. Here we argue on both the sides, both for and against, and we have a thorough research done. We identify the issues. It is like a problem solving scenario where we try to understand the issue there, try to bring in the solutions, do a lot of research, try to introduce our interpretation, and how to it is like a crisis management, problem solving skill is introduced to the student. Okay, so basically, as you all know, 3 members team: speaker 1, speaker 2, and a researcher. Okay, um, the speaker 1 usually presents the initial arguments, speaker 2 handles the remaining issues and rebuttals, researcher supports with documents, facts, and case law research. Okay, so now what I used to do is, like when you are sure that you have a good team, we used to interchange these roles amongst ourselves, so that each one of us gets to be mooter 1, mooter 2, and a researcher. Okay, so what are the skills that we hone during workshops? The advocacy skills, that is the oral advocacy, legal research, and drafting skills, right? Then, as I just told you, crisis management and problem solving skills. When I say crisis management, I wouldn't just refer to, see, problem solving skills are, we already have a moot problem and we are trying to understand what exactly could be the solution. How do we get past or get through this particular situation and try to help our client? Right? That is problem solving skill. But because you're participating in a national level competition and you're a group of three students, each coming from a different background, there are so many challenges that I myself as a mooter have come across. Just like Shambhavi was telling right before I began, that I was best lady advocate in SC Javli Moot, right? Trust me, tomorrow was a submission. My entire memorial was ready, and all of a sudden, because of some mistake done by one of my teammates, she selected Control A, the entire document, and somehow she presses space, the entire document is deleted, and then she saves it. So I come back and I see the entire petitioner side memorial is a blank Word document. Okay, but because we had thoroughly prepared, um, uh, the entire. I mean, the research was so thorough, and we knew what goes where. And at that time, we just sat down, all three of us. We decided that we are not going to cry over this film. We will complete it. We have time till tomorrow morning, and we will definitely make sure that we are going to do it. We are going to give our best shot, and we did it, of course. And yeah, we were the top three, and I also won the best lady advocate because I think I had drafted the entire petitioner side moot court almost 2 or 3 times, and even while arguing, when we had to pick the chits, we got petitioners twice. So I would say I was just lucky. But still, you should not lose hope. Sometimes there are certain situations where you end up being in a crisis unexpectedly. But yes, you learn how to deal with it. Research and critical thinking. This I'm sure you're already experiencing it, because you not only read a particular subject, but what do you do here? There is a problem situation where you have to dissect the problem, try to understand where exactly is what is the root cause, and what solution would mean that both the parties would be okay with work, right? So that is what we are trying to critically think. We are trying to understand the concept. The best possible solution for your client would be your interest. So you are trying to apply your critical thinking skills, and it sharpens your logical reasoning and public speaking under pressure. The bench would be posing a lot of questions. You will be, I would say they would be very critical sometimes. A lot of questions are being asked. You may start feeling a bit nervous. But then, yes, at the end of the day, you're learning how to handle that situation. Career benefits. Encourages legal creativity and analytical precision. If you are a mooter, you have participated in decent number of moot courts, even a couple of moot courts, right? If you have the certificates, when you apply for jobs, the recruiter would be definitely choosing you over somebody who is has not participated in moot courts, right? So you will be chosen over those other candidates. So networking and professional. Moot courts have really helped me with respect to networking and professional growth. I have been to many parts of the countries during my undergraduation, because I used to choose moot courts from different states. First of all, I would get to travel. That I enjoyed. Secondly, I used to meet a lot of people. Whether the entire experience, you meet people there. The hosts are very sweet. They have peers who are interacting with you. Then you meet other teams who are participating. You exchange numbers and you try to exchange ideas. I still have a lot of friends whom I have met through Moot courts, and professionally also. When I became a principal, I wanted to invite a lot of people from various walks of life, so that my students get inspired, right? So at that time, it really helped me a lot because I knew people from various states, and some people were practicing, some were in academics, some had just shifted to business, but all of them are really in touch, and we are really glad that we met over Moot courts. Yeah, and personal growth, teamwork, professionalism, adaptability, and confidence. So it helps us um, in developing our personality as well. So there are various stages for mood court journey. Okay, first of all, it begins with choosing which mood court should I take. Right, there are various options nowadays. Right, so selecting which mood court to go with. It depends on which subject you're interested in, your convenience, and depends on how suitable it is, how much time you can dedicate to that moot court, whether you can give your 100% to it. If you hardly have 1 week's time, you cannot do justice to such, by participating in that moot court, right? Also, if you do not have sufficient material available with regard to the subject matter, or if you do not have the basic knowledge about it, and you have to start over from the very beginning, and you have shortage of time, then it will be very difficult for you. You may not be able to give your 100%, right? So you have to choose which moot court competition you will be um, selecting. Then, moot problem. Moot problem is a very important document. So it is the mood problem that you will have to thoroughly read and analyze. I usually say that a mooder, the moment you get the mood problem, you read it a minimum of 10 times. Okay, it is not like some teacher giving you an imposition, sit down and read 10 times, write it down 10 times, 20 times. No, it's not like that. 10 times, because it is a minimum number of times where you read it, try to understand it. You should be thorough with the facts. So what I used to do is, whenever I used to read the mood problem, I even do that. I make sure that my students also do the same exercise. Whenever they read it, see, sometimes there are some words, there are some punctuations, there are some missing, there is something missing, or there is some grammatical mistake, right? Or there is some ambiguity, or there is some vague sentence. Can we make use of it? Maybe, maybe not, right? So you have to understand the mood problem properly. Okay, so for that you will have to read it repeatedly. Okay, more number of times you read it, and at various stages. Now, initially you read the mood problem, then after you start drafting the memorial, you again read it. You keep reading it, so that every time you get a different perspective of the entire fact sheet. Okay, develop strategies for the arguments. So once you read the entire mood problem, each and every team member should sit down and write down their perspective of the mood problem. Okay, and then the team should form a strategy as to how you're going to argue the case, how you're going to build your memorial, how you're going to build your case. You have to. That is very important. Okay, uh, it is very important. The fourth point, as you can see, formation of a strong, diverse team. Team is very important. Okay, because it is not an individual event, it is a team event. Each and every member of this moot court team is very important. They have their own crucial role to play. So hence it is very important that you choose your team wisely. Sometimes it so happens that we get carried away emotionally. Oh, we three are best friends and we are going to have only us in the team. It's not bad, but Are you going to develop after each moot? Sometimes yes, sometimes no. So you will have to choose your team wisely because it should be a learning experience. I have seen, it is very unfortunate though, I have seen some of the moot court teams um, coming to the venue, to the competition, and then the entire three members team, they have fought with each other. Okay. And to an extent that they they had to be sent back. So the coordination amongst the team members is very, very important. So choose your team wisely. And if you keep a diverse group of people, it is even better. Let's say there's a person from final year, one more from the first year, somebody from the 3 years law and has an engineering background, or has no, I hope you understand that if at all people from different background are coming together, they bring in their own knowledge, okay, their own experience that can add to the value of the team. Then once you come together and you start reading the mood problem, you have planned the strategy, you are supposed to write down. When I'm saying plan, plan how you're going about, you have to first write down the positive and negatives that you find in the mood problem for both the sides. Petitioner, these are the points for the petitioners, these are the points that are against the petitioner, respondent. Okay, you write the same, you make two different notes and start writing, start framing sentences both for and against both the parties. That is what I um, start my work with. Then division of roles and timeline setting is very important. See, initially in the first year I used to feel that it's a Herculean task, a moot court, it's a journey. You get all of a sudden, I felt overwhelmed that a huge moot court problem is there in front of me, and I didn't know, I wasn't sure if I'm even going to get through the entire thing. I hardly knew anything much. So what we as a team decided is, see, now it's a huge task in front of us. So what we'll do is we will divide it. No, we had 1 month time. That 1 month time, we divided it. Okay, the first 1 week we are going to do this work, and then we go to these libraries, we do the research there, and then last 2 days we are going to do the research in this library, then start the memorial. So we planned it accordingly, and we used to make sure that we divide the work as well. Okay, so that is also part of the strategy you use in your team. Okay.
Excuse me, ma'am.
Yes,
Sorry
please.
to interrupt. Ma'am, your slides aren't changing.
No, I'm just discussing about the stages of a mood board journey.
Okay, ma'am.
So your team members are very important. And then I was discussing the sixth point here. So there is no shortcut. Okay. If you have chosen a mood board and you're passionate about mooting, you have to make sure that you do the in-depth research about the subject. Okay, the case laws, the history, if there were any reports by any commission, newspaper articles regarding it. I had once taken a moot court about an environmental uh, cause, and we had done a thorough research about um, dams, the positive and negatives of it, right? So in-depth research always helps you understand the problem, and sometimes um, you can derive the solution through the general read as well. Okay? So in-depth research, the previous law which was existing, the law which is currently there, try to analyze, try to understand what is the difference, and try to understand the impact of this legislation on the society. Okay, and then read as many case laws as possible. Actually read it. Okay, don't just copy it from some book and paste it. Read the case laws. Now this is a time when you're actually going to read it in detail. And trust me, all the in detail reading that I've done during my boot course has been helping me till date. The hard work that really pays off, even at the later stages of your life. So don't use a shortcut. Rather, uh, you know, um, enjoy the process, enjoy the journey where you read a lot and then try to come up with a solution all by yourself. That feeling when you come up with a good solution or a better argument, that's wonderful. You have to enjoy this journey. Yeah. Then comes the memorial drafting. Okay, memorial drafting, proofreading, and compliance. Compliance in the sense you have to submit it on time, right? There are each and every competition has its own rules. So according to it, we will have to draft a memorial and then make sure that we are proofreading it. We can reach out to our mentors. We can reach out to our seniors, other friends in our class. Then proofreading is very important. Then comes the practice rounds, that is the oral argument preparation. Um, Often we do this mistake that once we sit down to draft the memorial, right? So we tend to, make it perfect. We go on adding a lot of materials, and then we start thinking that, okay, I'm trying to improvise it. Maybe I have to, and we spend a lot of time in just drafting the memorial, and somehow we think that, okay, oral round, the same thing we will have to present it there. So I'll go home, I'll just go read it, and then maybe on that particular day, one fine day, I'll just go and start arguing. No, that's not how it is done. Moot court calls for thorough preparation. Okay. When I say thorough preparation, when I'm saying that no, you are supposed to do it this way, when you are supposed to do it a certain way, you may think that no, how does it matter? See, trust me, I have, there was this. I would definitely want to share this experience where I was arguing for one of the moot courts. The preparation was so thorough. The confidence that I had about the subject matter, the issues, the cases that are there, the confidence was so high. And I was just waiting for the judge to ask a question. It's like you just ask a question and see what answer I'm going to give. That kind of confidence. And that gives you a different level of high, trust me. You start enjoying the research. You start enjoying the entire moot court experience when you actually have that confidence. When they ask you a question and then your brain starts responding with, on spot witty responses. Yes, that happens. And that happens when you have thorough preparation. And if you want to do it, there is no shortcut. You have to do it the hard way. That is, hard work is a must. You have to do the thorough, in-depth reading and research. Okay, so practice oral round. Don't neglect that part. Okay, the more you practice in front of your peers, in front of your mentors, they give you a feedback. Okay, they give you a feedback, and then you try to improve yourself. Maybe what you can do, you can record your arguments, and then see, maybe 10 years down the lane when you've recorded it and you're watching the video, it is really going to bring back a lot of good memories. That's definitely there. But before, as a tool for preparation, that will help you improve yourself, right? Later, when I'm talking about oral arguments, I'm going to talk about your voice, okay? Your voice modulation, your body language, all these things, what role they play, okay? So all these things, it will help you if you can record it and then play, and then you can improve yourself after watching it then. So preliminary and final rounds, as I told you, preparing a strategy for how you go about in your preliminary round and your final round, I mean semi-finals and final round, all these things you have to plan it in advance. I remember, I think in my second year, and I was mooting in Kerala Law Academy, I had met a team, and the way they went, and they know they took the prize, and then they came down, and then we asked them, you were quite coordinated when you went on stage and then you came back. They told me, yeah, our teacher told us that, our teacher made sure that we practice how we go on stage and collect the prize. Can you imagine the kind of preparation they have done? Not just the moot courts, not just the memorial and oral argument. They have even prepared how they're going to walk on stage, how are they going to stand, who is going to stand where, and then collect the prize. Okay, so they were organized and well prepared for the moot court. Okay, then after the preliminary and final rounds, please don't forget the rebuttal and sur-rebuttal rounds. Um, uh, these are very crucial, and they can fetch you some extra brownie points. Okay, and try to ask for feedback from the judges. Okay, this helps in improving self-reflection, and it helps you learn and improvise yourself for the in the next week. So there are certain rules and etiquettes for a moot court. Okay, few things are common in all the moot courts. Okay, first thing is no alteration of facts or memorial. Whatever whatever facts have been provided to you, the moot problem, you cannot alter it. It remains the same. At no point of time, sometimes what they do is, some of the teams, they in their memorial, they try to, they're trying to uh, draft the moot problem from the client perspective. You can do that. But however, you should be very careful that you're not changing or tampering with the facts. The facts remain the same. You cannot change that. Okay. Then citation. In the current competition, Blue Book 21st edition, uh, depends on each and every competition. Okay. Then a professional dress code, um, dress like an advocate, no scouting. You cannot, you cannot have people going around in various courtrooms, try to find out some information from there, some argument or case law from some other court, and then present, give you the information. That will not be allowed in any of the moot court competitions. Then, when it comes to division of the issues between the two mooters, make sure that you're having the equal division. Right? I have seen this in amongst a couple of, see, that is where I say that the team coordination plays a very important role, right? One mooter is just given one issue, the other one is very dominating. He says, no, you cannot do it, I'm going to argue the next three. You cannot do that. You have to equally divide the issues amongst yourself. Okay? Maintain the decorum of the courtroom. Stand when the judges enter. Use legal language. Professional behavior. Follow the courtroom etiquettes. Okay? See, a moot court, as I told you, there are various stages of in a moot court journey. There are various stages. But if you just divide them into simple 3 or 4, divisions. First thing is the moot problem, okay, then the legal research and memorial, then comes the oral argument. Okay, so moot problem I've just discussed with you. Legal research, as I've told you, read it multiple times, spot every nuance. Okay, use a lot of uh, sources like SEC Online, Manupatra, JSTOR, in the legal databases. See, I used to even go to the law library. I remember my entire team used to go and sit in the library and then bring in all the law journals. We had wonderful library in Karnataka University, Dharwad, and we had journals from across the globe, and right from 1800s we had all the back copies. So we used to go and just take out articles, dig in, and we used to study everything possible that we used to collect all the information from the journals as well. Articles also we could read. Now we have a lot of options. Earlier we had Manupatra and SEC Online. Now um, there are a lot of other options also available. So you have to be thorough in your research. Okay, and this is what I was talking about. Team strategies. Okay, every team. Okay, depending on your strengths and weaknesses. We all have our own strengths and weaknesses, right? So every round, okay, you can develop a different strategy as to how we're going to present ourselves in the next round. How are we going to present this argument? See, I'll give an example. Let's say there is a moot problem where usually we have certain good points that are very much in your favor. There are few other points which are against you, right? So when you have thoroughly prepared on both the sides, you know the positives and negatives, right? So there are certain points where you do not, you know for sure that that is not one of your strengths, right? So how do you overcome it? Or when you are arguing that particular issue, how do you make sure that you somehow cover it up or try to bring in a different research, or that is all part of the strategy. Okay, and many moot courts, there is a memorial exchange round, right? There is a memorial exchange round, and you get to understand the research, the arguments that your opponent is going to place in the competition. So that is the best time for you to get together, discuss it, try to understand how you can give a better counter at that particular point of time, right? Prepare, write down notes every now and then. When you think that you found something new and better, every stage of this moot court, you can make notes and try to implement it. Okay. This is very interesting. Earlier, this is not allowed in all the usually not in all the moot court competitions, but some teams in the when we were mooting, they used to have a separate memorial just in case I get into the final round. This will be my moot memorial. Okay, they used to submit it to the teams. That used to be allowed earlier also in some of the moot courts. So they see, it is not so easy, right? If you if you're participating in a moot court, what would we normally do? We give in our best in every round. But there are few people who they used to think that, okay, if this important case law that we have found, this shouldn't go in the first round itself. So maybe in the subsequent round, I'm going to place this at a maybe second or third round. Okay? So that used to be allowed. So you have to first make sure that whether it is allowed or not in your competition. Then you can even interchange speaker 1 and 2, depending on your positives and negatives, right? So what I used to do is I used to be the speaker 1, but I used to argue the third and the fourth issue. Okay, the third and the fourth issue. Because I was more confident with regard to those two issues. I used to not just think that, okay, I'm speaker one and I am supposed to argue the first two issues because I'm the senior or anything. No, it doesn't work like that. We are a team, right? We are a team, and we just want our team to perform well in the moot court competition, right? So, depending on which issue, um, which team member is comfortable with which issue, we could interchange the issues as well. Good team coordination is the key. You need to make sure that you have a good team bond. Then let's come to the memorial. Okay. As you all know, whatever oral submission that you're going to do in your oral round, it is dependent on the matter that you have submitted in the memorials. Right? Memorials are very crucial. Then you should make sure that there is clarity. You avoid vague statements. That you use simple sentences. Don't confuse the reader. Okay? And memorials are divided into formal pages and the arguments, or technical pages and the arguments. Okay, the formal pages or technical pages, because see, this is a academic exercise. We are trying to train you for the practical scenario, but then we are this is actually a academic exercise, right? So to help you develop your research skills, the memorial includes a lot of research, and then it is more like uh, what do you say, article writing to an extent. Okay, it's a mixture of both. So you have a certain set of technical pages that are important, the formal pages, like the title sheet is there even in the claim that we submit. Then we have the table of contents, the jurisdiction, we have the fact sheet, we have various formal pages, summary of issues, issues raised, summary of issues, and then arguments advanced and prayer, right? So the formal pages, we used to usually mark them with small Roman numerals, and arguments, we used to mark them with the numericals. But again, as I say this, depends on each competition's rules. So here, in this competition, I believe they want you to mark from 1 to 35, because 35 is the maximum number of pages, right? Sometimes the moot problem does not have the list of issues. So in that case, the mooters themselves have to identify the issues. This is very interesting, okay? Because you are trying to find out the points of dispute. What are the points of disputes? When one party agrees to something, then the other party is denying it. Okay, so these are the issues or points of dispute. So you have to find out that points, those points of disputes. Normally in the courts, the court you know um, lists out the issues. So once the issues are identified, um, very important step. This also affects the oral arguments. So very important step here is you are supposed to arrange the issues in a certain manner. Okay, you should ensure that there is no overlapping of subject. Okay, so let's say if it is the issue regarding maintainability of the case, it always goes in the first issue, because whether you're even allowed to present, file a case before the court or no, whether the court has the jurisdiction or no, is first decided, right? That is a primary issue, no doubt about it. When it comes to the second and subsequent issues, it should be drafted in a certain way that if you're arguing the second issue, it shouldn't become inevitable for you to start explaining what is there in the third and fourth issue. If you were supposed to explain the third and fourth issue in the second issue itself, then the way you have arranged the issues is completely wrong. It is inconvenient, and it creates a kind of confusion. Your next team member is also going to speak about the same things, right? So your arrangement of issues is also very important. Okay, arrange it in certain in a manner where the subject matters don't overlap each other. Try to avoid it. Okay, and when the judges are asking you questions about some of the points that your co-counsel would be discussing, you may explain it in brief and then request the honorable court politely that the bench may permit the co-counsel to present the details, right? Then facts of the case. As I told you previously, facts very important. It is, see, some people, when they draft the memorial, they use the facts, and based on the facts, you go on telling, Your Honor, in the present case, and these are the facts, and in between, they even start telling the issues, and they weave in the arguments, they weave in the case laws, and it's almost like a story. You can present it in a very beautiful way. So you should take it from the facts, and then you have to go on adding the arguments in it, right? So that is how you have to draft each and every issue in the memorial as well as oral arguments. Summary of arguments. Uh, some people may not know the importance of summary of arguments, but when I was mooting, and many times I even make sure my students are also doing it, summary of arguments is a gist of all the major arguments that you're going to place before the judges. Okay, so I used to just open the summary of arguments in front of me. Smaller notes I would have just scribbled. I used to have the sticky notes placed there. Okay, issue wise, I'm just explaining everything extempore. I just have to glance, making sure that I've not missed any of the major arguments that I'm going to place before the court with regard to that issue, right? So it is just like a highlight point, a reminder that these are the 3 points that I'm supposed to cover in this issue. So the moment I see point number 1, I immediately have 1 or 2 sticky notes where I have the important case notes with regard to that. I start arguing it. Okay. Then before completing that issue, I make sure I glance to ensure that I have not missed any of the arguments that I'm supposed to place before the court with regard to that issue. So it is very convenient for oral argument. So while drafting this summary of arguments, make sure that you are having the gist of all the arguments that you're going to place there. Okay. Then arguments advanced. This is in detail, explanation, or you would say the case that you're going to present before the bench, right? So issue wise, you're going to explain it in the memorial. The same thing goes with the oral arguments as well. So how do you do it? It starts with, see, issue number 1, whether the present case is mentionable. It is most humbly submitted before this honorable court that the present case is mentionable. And when you end the issue, hence, because you have already explained, right? You have presented the facts, then you have presented these are the arguments, you have presented some important precedents, right? Once you do that at the end, you say, hence, it is most humbly submitted before this honorable court that the present case is maintained. Okay, so you start with that statement, a certain statement, and then you end with 1. Okay, the facts of the case are very important. Okay, and you have to present the facts positively. And in the fact sheet or in your memorial, let's say it's a memorial for the petitioner, you can write it. Write means you can condense the fact. Okay, and you can present it as you would want to present it from your client's perspective. But however, make sure that you're not altering anything there. Okay, altering in the sense deleting an important sentence or deleting some facts that will, that are pro your opponent. No, you cannot do that. You can only condense it and reduce it to 1 page or 1.5 page. That can be done. Okay. The facts of the case are important. Then plagiarism is definitely a no, and you should be very careful about it. Whenever you're borrowing some information, some knowledge from other sources, make sure that you are using with the help of citation methods, you are citing the author, giving credit to the author in the footnotes. Okay. In fact, in the footnotes have multiple uses. Okay. You can give the credit to the author. Okay. And from the reader's perspective, the person who is reading your uh, your document, it could be an article, it could be a memorial, when the person is reading your research work, the reader can go to the footnote and then find out the further read from there. Okay. And the third important thing here is there are few things that you cannot give a further explanation in the main page. Okay. In the main argument or in the main narrative, you do not have scope for explaining certain things, but you can do that in the footnotes. Okay. So now, when it comes to Nyaya Shastra moot court competition, there are certain rules that you have for the memorial drafting. Right? Cover page, it should include the team code of the team on upper right hand corner. And as usual, you should write the name of the case. This is a cause title. Okay. What should a cause title have? The team code on upper right hand, then the name of the case, the parties, okay, the forum before which you have come for the dispute resolution, year, okay. Then the cover page for petitioner should be in blue and respondent should be in red. Then the next sheet would be table of contents, add paginations, so that it will be very convenient for the person who is reading the evaluator, even for you. See, when we are doing the oral arguments, what we usually do is, if you are explaining something from your memorial, you can refer a certain paragraph, a certain page number to the bench, saying that Your Honor, may kindly look into page 4 of the memorial, paragraph 2, line 3. Okay, so you can request the honorable bench, can divert the attention of the honorable bench into a particular page number. So it is very important to paginate it, use highlighters wherever needed, flags. Okay, that shows how organized you are. Then list of abbreviations, all the abbreviations that you've used in that memorial, you can list them alphabetically, list them and put them in the list of abbreviations. Then texts of authorities, the articles, books, cases, the web sources, okay, all these, the dictionaries, statutes, you can just list all of them alphabetically. Okay. Then statement of jurisdiction, of course this provision of law under which you have approached the court. Then statement of facts, I've explained it to you how you can draft them. Issues raised, what are the issues that have been raised? Issues could be sometimes 2, sometimes 3 and 4, and it will be very convenient for you to make some sub issues also. If at all the issues have not been provided, you can even go for sub issues, like for example, whether the legislation, whether the current legislation is ultra vires the constitution. In that, you can make 2 or 3 sub issues, like whether it violates Article 14, whether it violates Article 21, whether it violates Article 19, as such, rather than making 3 different issues, whether it violates so and so and all that. Instead of doing that, you can make sub issues also. Okay, so issues raised. Then I told you summary of arguments, arguments advanced, and prayer. So in the prayer, um, unless and until you have some such fact wherein you have some special prayer which has been mentioned, respondent usually is not having a detailed prayer. Usually is to dispose of the case. Okay. But sometimes we tend to write a lot of things. You hold this, kindly hold that. It is prayed before the honorable court to decide in this manner. No, you cannot go on telling these things to the court. Okay? But a petitioner has approached the court to seek certain prayers, so a petitioner is allowed to. Okay? Annexures are optional. Okay? Font and spacing, usually it is A4 size paper, Times New Roman, that is a font type. Font size will be 12, footnote 10. This is usually common for the moot courts. Line spacing 1.5, footnote 1. Alignment should be justified. Margin 1 inch on each side. Number of pages, maximum number of pages is 35 pages in total, excluding the annexure. Annexures are not counted here. So again, it is the discretion of the team to either submit the compendium or not. Okay, extra marks are not given here, and the citation method will be 21st Blue Book method of 21st edition of Blue Book method of citation. Okay, Howard Blue Book. So, what is the compendium? Can somebody tell me? Can somebody tell me what is a compendium?
Ma'am, the compendium is the collection of all the cases that we have used to prove the basic to prove the authenticity of the cases, and so that the judges know that where the case laws are from and the no.
Good. May I know your name?
Anshuman.
Anshuman, thank you so much for your answer. Yes, you're right. So basically, what we're trying to do is we have a compilation of all the materials that we want to submit to the court. Okay, the sources, the precedents, right? The various research works that we have done. It could be even a report by some committee. Okay, you can bring in all the important pages in one place. Make sure that you use highlighter to highlight the important sentences that you want to bring to the attention of the judge. Use the flags, use the post-its, and you submit it to the court. Right? This is a compendium. Right? So it depends on the team's strategy, I would say. Okay. See, I have even participated in second CMR National Moot Court competition where we won the best memorial. And I observed one thing. We had a compendium. Okay. And of course, we had submitted it initially, but rather our opponents, okay, what they did is they chose to give each and every information as and when the mooter was arguing. The researchers was very active. I'm going to discuss that a little later. Okay, so a researcher goes on submitting it. So that also gave a certain kind of impression that though both the parties were submitting equal number of materials, the bench later on, while giving the opinion, they said that the respondent seemed to be submitting a lot of material, right? So sometimes it all depends on that particular situation, how you're going to change your strategy. Okay, now if I feel that the opponent is doing this, I can also immediately shift to submitting it independently. So it is left to you. You may submit as compendium, or individually you can just go on submitting the individual cases as and when your teammate is ordering it. Okay, for that you will have to have a strong researcher, a strong, a person who is thorough with all the research that the entire team has done. So it is very important that the researcher is very active. Okay, if you have that, and as and when the researcher should be completely aware of what are the arguments that Muta number 1 is going to present, and then what Muta number 2 is going to present. And if this question is asked, what will be the answer, and immediately have to pass on this information to the bench clerk. Okay, if you're that fast, then you can definitely go on submitting the documents one by one. Because I'm arguing something, I just look at the researcher, and the researcher should know what document to be submitted. Okay, then it is very effective. Or else compendium is fine. Okay, oral arguments now very important. Partially, I've already explained it to you. Okay, preparation very important. You cannot skip that part. Rehearsals are important. I myself use, whenever I have done the initially I used to not concentrate much on rehearsing the oral rounds. I used to just think that I'll go home and I'll just read it, I'll just say it in front of the mirror and I'll be fine. No, it's not true. When you practice in front of your peers or in front of your mentors, you start gaining a certain kind of confidence, right? That you will get only when you actually argue. You might find it a bit tedious in the first round or maybe second round, but gradually you find that confidence, and by the time you're actually presenting it in the competition, you would have had that your arguments would have a certain ease. The flow would be really good. You know what to say and when, what question to expect from the judges. Your brain starts working in a certain manner. You know what exactly is being will be asked now. Then okay, this I usually make sure that all the booters whom I usually train, or I kind of help them, I make sure that they follow this. Dressing neatly and professionally is very important. Doesn't mean that you are supposed to wear only western dresses. It could be even a sari or a kurta, but you should make sure that you look confident, you're comfortable in what you're wearing. Okay, and you should dress professionally. Too much of makeup, looking, all these things might not be might not keep you give you that confidence that you know otherwise you could. Because sometimes you start feeling too hot, you're not comfortable, because ultimately you've gone there, you're standing there so that you convince the judge, so that you make an impression before the judge. If you're yourself not comfortable, and you don't find it convenient to stand there, then no point in all the dressing, right? So your dress should be comfortable, neat and professional. Right from, see, the moment when you enter, just you ask the honorable bench, your honor, may I approach the bench, correct? So when you do that, the way you're standing, usually there's a bench where all three of you are there, right? From there, to yeah, I forgot that you give me this, you give me that. No, that shouldn't happen. Everything should be neatly kept in your folders. Your material should be prepared, properly flagged. Your stationery, the essential stationery should be present there, very organized. Okay, that gives a impression to not only the bench or the evaluators, but also to everybody else, including your opponents. Okay, when you are showing a lot of confidence, when you exuberate a lot of confidence, and you're organized, you're neat, you're prepared, that somehow gives an impression on your opponents as well, right? So make sure that you keep everything ready. Okay, that preparation should be to that level. That's what I'm trying to tell you. Okay, then you know as I told you, your preparation, during your preparation, if your preparation is good, then you should make sure that you are noting down all the possible questions, try to find the answers for them. Be prepared for the judges to interrupt you. You shouldn't feel annoyed. Okay? You should be ready to answer the questions. Don't dodge the questions. Very important. Many a times I've seen people saying that whenever they're asking you, if you don't understand, if you don't know the answer, you confuse them. No, don't do that. First of all, make sure that you are thorough with your research and be sincere, be honest, because these are some of the important lamps of advocacy, right? So you should be honest in the sense you should make sure that you're honestly preparing. You should be doing your hard work, and then when you're standing there, don't dodge the question. Because why are you standing there? Tell me. Why exactly are you there? You're representing your client. You have to make an impression before the judge. You have to convince the judge. Convince what? That your client is correct. Unless and until the judge feels that all the points, all the confusions that are there in his mind are resolved by you, the judge will still feel that, okay, there is something that he will realize it, okay? He would have asked you a question at that time temporarily, you've just somehow made sure that you dodge the question, you answer something vaguely, and the judge is keeping quiet. No, that stays in his mind. Okay, that somehow he did not answer my question. Okay, so avoid doing that. Rather, make sure that you're waiting. I told you, initially that if your preparation is really good, you're just waiting for the judge to pose a question, and then randomly you come up with some answers that you just feel so proud of yourself. It may be witty, it may be something that you never expected that you could, you could do, right? Then that's the time when you pat your own back. You feel, yes, I did something nice today. I enjoyed the argument, right? One such I can tell you, there was a time when I was arguing, and there was a certain question asked by the judges. They knew that I'm going to give, I was just waiting for them to ask me a question, and I used to give them some surprising answer. And they were just waiting, what will she answer for this? All five of them in the semi-final rounds, they were so adamant. They were like, you tell us, is it yes? Do you agree? Do you agree? Do you agree? If if A happens, then B is the result. Do you agree? Do you agree? They're not letting me speak. I kept quiet and they smiled. I said, Your Honor, yes, I agree that A could lead to B. And they were like, yes, that's what I told you. But Your Honor, kindly, I beg to differ here. It is possible. I agree that A could lead to B. But however, okay, I do not accept it in the current scenario. Because by that time, the judges who were very headstrong, they were telling that no, she has to agree to what I'm saying, right? They felt that yes, she agreed to what I said. Then I said, however, Your Honor, I beg to differ that A could lead to B, I agree, but in this scenario, however, it does not. I do not accept it, right? So they were all having a beautiful smile and they appreciated. And I remember one of the parents who was standing, they couldn't control, they stood up and started clapping. Of course, that's not allowed. But then that, whether you won a competition, you've not won a competition, but there are few things that stay with you. There are few proud moments that stay with you. So that's why I say mooting is an experience. Okay. It is not just some exercise, not just any competition where you just go read something and then come back. No, it's not that. It just becomes a part of you. Okay. As I told you, your personality, enhances. It teaches you life skills, problem solving skills. If you're in a certain situation, how do you talk your way out? There is a saying in Kannada, okay? ಮಾತು ಬಲ್ಲವನಿಗೆ ಜಗಳವಿಲ್ಲ, ಊಟ ಬಲ್ಲವನಿಗೆ ರೋಗ ಇಲ್ಲ. So the person who knows how to talk will not quarrel, will not get into quarrels. A person who knows how to eat will not get ill. Okay? So You should know how to talk. Being an advocate is not about just talking. It is when to talk, when not to talk, how much to talk, and how to talk. Right? So that is a skill that you'll have to learn. And moot courts help you develop that skill. How to ensure that you are finding a solution to the problem in front of you. Right? Anticipate the counter arguments, try to answer rebuttal and surrebuttals. You should make maximum use of these two, and make sure that you are noting down all the points when your opponent is arguing. Okay, and keep preparing. Search for the counter arguments, and you shouldn't just vaguely place anything for the rebuttal and surrebuttal. You should thoroughly research at that particular time and then come back with the argument, not something that you have already said in your arguments. Okay, manage time, very important. It so happens that sometimes moot courts, each and every round, if at all we are taking around half an hour, or we are going on extending 10 minutes, 15 minutes. So at that moment, you may think that, you got a chance to explain something better. But then overall, the, conducting of the competition, the host would also have prepared it in a certain way. And then your skill is exhibited only when you could do all of this in a given particular amount of time, right? It is time bound. So if you're extending it, then it is not sign of a good mooter. Okay, try to make sure that within that given limited time, you are going to argue everything that is there in your memorial in a better way. So the best thing to do here is use your summary of arguments and explain the case as you understand it. Okay, extempore. Okay, you understand the subject matter, you place the issue before the court and explain what you understand about it rather than reading it. Don't read it. Okay, then yeah, I think you should be persuasive. Ultimately, you're standing before the court so that you can convince the bench. Okay, so convince the bench. Okay, role of a researcher, very important. Sometimes I have seen that there is a tendency that when there are two people who are good mooters, they just ask somebody to just tag along, saying that okay, you will also get a researcher certificate, you can join me. No, that's not the right way. Researcher plays a very crucial role here. As I told you, that researcher is thorough with the entire research, knows what argument the mooter 1 is going to place, mooter 2, what are the positive points of mooter 1 and 2. And when we have a certain opponent, if you know that, if you have already read the memorials along with the mooter 1 and 2, it is a researcher who should be main lead for preparing the strategy, because researcher is the one who is the connection between the two mooters. Okay, that a very important part of a moot team is a researcher. Many competitions even have a researcher test. That is because researcher plays a very important role in a moot court. So if at all one of the mooter is struck, or some question is being asked, and then you're not sure if mooter 1 will be able to answer, you can immediately write down in the chat and you can pass it to the court officer. Okay, so like that, the researcher will be helping the mooters in the argument stage. But though he is not arguing by himself, sometimes with the permission of the bench, researcher can, if at all permitted, the researcher can also place before the court a certain argument. Okay, okay, there are certain guiding lamps of advocacy. I've added it because if you see these, the moot court enhances these qualities in us. Okay, industry, eloquence, tact, honesty, courage, fellowship, judgment, wit. Okay, these are the 7 guiding lamps. And 8th one is the wit. Wit is using humor, along with you have to be smart and also use humor in what you are going to say before the bench, your arguments. Right. So these qualities are expected of you. You should show these qualities as an advocate in front of the bench when you're doing your moot court. Okay, industry, hard work, good presentation skills, good communication skills, okay, and problem solving ability. You should be honest. You should show confidence and courage, right? And you should have a good team bonding, and you should not see, fellowship is not just limited to your team. As I told you, I have so many teams. It could be from Mumbai, Pune, Delhi, across Maharashtra, Tamil Nadu. I have so many friends from other moot court, other colleges because of the moot courts. So that shows the fellowship. You have a lot of you already are knowing a lot of people from various schools and colleges because you're participating in a certain moot court, right? So you should not misbehave with each other. Okay, they are also here. That's good sportsmanship should be there. Okay, so these are the things that I wanted to bring before you. So why should you do a moot court? Because it is not just a competition. Okay, once a mooter is always a mooter. I still call myself a mooter. You can check my LinkedIn profile. I still identify myself as a mooter. So it's a transformative experience. Okay, every person, once you do a moot court, you learn, you grow. Okay, you learn a lot of life skills, you meet people. Okay, it is a transformation. There is a lot of difference between a law student who is just into academics and the one who is a mooter. The way you understand a problem, the way you try to know your perspective of looking into a problem, how to solve the problem, everything changes. And this continues even in your life as well. Okay, so how do you interact with people, how do you solve the problem situation? Okay, um, all these things will help you even in your real life and also in your professional, of course, in your professional life, right? The number of moots that you have done, the certifications, if you have won some moot courts, if you have won some prizes, so all these things would really matter when your resume would actually outshine others who are not, right? So it is always a win-win situation. Unlike other types of competitions, here we are, it is not just about winning a prize, first prize, second prize, this prize, that. This is just, it is there, it is appreciated definitely, but each and every person who has been through this journey is a winner. Okay, who has gained immense knowledge about the subject, has transformed himself, has learned a lot of life skills, has made so many professional friends. His networking is strong. There are a lot of benefits, right? So moot court is not just a competition. It is much more than that. Okay. So a quick recap. Mooting, it means research, strategy, um, good communication. I'm sorry, I've written speaking there. Teamwork, good communication. Okay, and you have to keep on practicing. Keep practicing. Okay, as many moots as possible. Also, as many oral rounds as possible before your peers, before your mentors, etc. Okay, and always respect the rules. Whatever rules of the competition, you please respect it and try to make sure that you're following them. Enjoy the journey. Okay, you will enjoy it. More number of moots you do, and sincerity is very important. Do your hard work, be sincere and honest. You will enjoy it. You will thoroughly enjoy it. Okay, let mooting shape you into a future ready lawyer. I wish you all the best for the moot courts. Okay, and if you have any questions, I would like to answer them. Hello. Am I audible?
Yes, ma'am, you are audible. They are asking question in the message box.
Oh, is it? Okay. Sorry, I didn't see that. Okay, I think the question here is There is a team comprising of 2 members, and who would be the researcher. And I think this question will be asked by the answered by the host. Madam Shambhavi,
Yes, ma'am. Yes, ma'am.
can you see the question?
Yes, ma'am. Ma'am, there
Yeah.
will be no researchers test.
Okay, no researchers. Can you get this PPT? Yeah, sure. I will share it with your madam. How to frame arguments for memorial. What is compendium? I think I explained compendium. You want me to explain it once again? What can be the right way to frame arguments in memorial? Okay. See, as I've tried to explain it previously. Issue number 1. Okay, you're always. I feel the right way of drafting a memorial is always through the facts, because that is why we are here. A certain thing happened. This is the fact, and because of that, there is a dispute, and then we have come before the we have come for the dispute resolution, right? So start with the facts. Okay, this is the fact, and because of that, this is the issue, and then you try to bring in the relevant um, legislation, legal principle, or precedent to explain or to support your argument. Okay, each and every issue could be having, varying from 1 to 2 or 3 arguments to support that particular issue, right? So you have to first recognize that. Okay, after you read the mood problem, you note down what are the different strong arguments that you are having for this particular issue. Could be a strong legal point, a factual point which is very strong on your side. It could be a mixed question of, it could be a mixture of both law and fact. Okay, so you can arrange these arguments accordingly depending on how strong they are. The strongest argument should be placed first, and then uh, the next one. Okay, so um, there are some arguments which you know just it is there. You do not consider it to be a very strong argument, but you just want to add it. That can also be added, but at the end. Okay, so like that you can arrange the argument issue wise. Okay, you have to justify. See, there is a difference between a lawman and a layman. Why is it? Because you understand the law thoroughly, and also, see, there is difference between a learned person and a non-learned person. Because when a person who is understood to be a learned would always have some deep research before saying something, right? Wouldn't just make vague statements just like that. Whenever I say something, if I'm valued, it is because what I say is because of certain experience. It comes from certain experience, it comes from certain learning, right? So your research work should show how prepared, how learned you are. You should always support your arguments with sufficient sources, materials. It could be in the form of the footnotes, the case laws. It could be in the form of the compendium or the material that you're submitting in your oral rounds. Okay, the list of authorities in your memorial, in the formal pages. See, I used to have some 4 or 5 pages minimum of list of authorities, and these are not something just vague. Sometimes people just read some book, you copy from there, and then whatever citations they put, the same you have copied. No, that shouldn't be the thing. That shouldn't be the case. You actually read the cases. You try to make um, the gist summary, try to understand, try to find the ratio decidendi of it, you know write it down in the notes. Randomly the judge may ask you, they may just say, see, counsel, just go to, because I've judged certain notes, I do that. Counsel, please go to page number 12, and in the footnote you have mentioned so and so case. Tell me what are the facts of the case, what is the ratio decidendi in that case. Okay, Are you prepared to answer this question? Depends on of a judge to judge in a moot court. You're participating in a moot court, it doesn't end there. You're actually exhibiting your talent, you're actually exhibiting your hard work, your skills before professionals, also your colleagues. The other participants are actually your colleagues, isn't it? So you get a chance to exhibit your hard work and talent before them. And if you're really a good mooter, you've done thorough research, you're already making an impression on their minds, not just for that moot court, also for life, isn't it? So some of the judges who had judged my not memory, oral rounds, I still know them and they appreciate me for it. Okay, so uh, your arguments, as I said, it should be arranged in a certain way. The strongest first, and then the weaker, comparatively weaker. If it is too weak and it is going to bring you some pain later, don't. I mean, you should avoid it, right? And if you're having an argument which fits much better in your further issues, you better add it to the next issue rather than bringing it here. There should be no overlapping of the arguments. Did that answer your question? Do you want any further explanation regarding the same? Ma'am, please explain what all is included in a compendium. Okay, compendium is a document where, see, in oral round, as I told you, you have, uh, you have arranged your arguments issue-wise, right? To support those issues, you have used certain precedents, certain of the research work, right? That research work you would want to present it, because you cannot just say, okay, so and so case and then end it there. You will have to submit it before the court saying that, see, this is the case. I have, sourced it from maybe Manupatra, any legal database, or maybe even from textbook. There could be some material available in a textbook and you can submit it to the bench in the moot court. So you use that and you are submitting it to the court. Okay, so that you try to establish the authenticity of the source from where you have done the research. Okay, so you can make a collection of all those materials that you want to present it before the bench, and you can neatly get a spiral bind, or you can get it bound. You can even add a table of contents, page in it all the pages in that compendium. That is called a compendium. Compendium is a collection of all the resources that you are going to submit to the bench with regard to your oral submissions. Okay, all the resources that all the sources that you want to submit to prove your arguments. From where did you derive that argument? How do you substantiate that argument? Right? It is not just me who is saying it. There are many others who have said it. The High Court of Karnataka has said it. The Supreme Court has said it. Okay, this is what so and so judge has to say. This is what Saman has to say. This is what a certain newspaper article says. A learned scholar, Justice Bhagavati said so and so in a certain case. This is not just my argument, it is something that Honorable Chief Justice has said in this interview, or in this. You can just go on adding all of that. You can make a collection and you can submit whatever you want to use to substantiate your argument. All those materials you can put it in a collection and you can submit it to the bench. Okay, that is a compendium. Again, because it has a lot of information, it will be not so easy to open it and then find out. You cannot expect the judges to do that because the time is very limited, right? So what you do is you have you have compiled it. You have a table of contents, but go on differentiating each and every case. Add flags. right? Sticky notes. And in that, maybe you write so and so case. If it is green, if it is red flag, it is for the respondent. If it is blue flag, it is for the petitioner. You can have two different, um, you can have two different compendiums, one for the petitioner side, one for the respondent side. Use highlighters so that you can highlight the ratio decidendi, the important part of the document that you want the honorable bench to read, go through, right? So that is how you can submit the compendium. Anything else you would want me to explain? How many of you are first time voters? Can you tell me? First time. Two. Okay. Okay. So I hope I have um, clarified some of your doubts. If you have any confusion, you can please, you can go ahead and type it. You can let me know. As I told you, um, I had no clue about what is a moot court when I entered law school. And there was this panel selection, and around 350 of them had participated in it. And as a first time voter, everybody discouraged, saying that no, you will be a fool in front of all of them. Seniors are very good. You'll not be able to get through. Why are you even participating and all that? But I thought, okay, it's okay. It's a learning experience. Um, they're going to make fun of me. I'm going to, improve myself next time. I cannot just, uh, you know, let go of this opportunity. I participated in it, and the first moot I had been there. I have this experience. I told you should equally divide the issues amongst the mooter one and two. I was bullied. I was told that I will be given only one um, issue, which was not even relevant, and the other one, and this was pointed out by the judges that no, you are not supposed to do that. Equal distribution of the issues should be there. And from there, to a point where I was considered one of the best mooters in the college. Yes, I was bullied initially, but then I proved myself, not to prove it to somebody else. I wanted to improve myself, and I started loving the journey, because you put in your hard work, you study, you see the results all by yourself. You get to meet people, you get to travel across the country, you know, that's all a win-win situation, right? So I used to thoroughly enjoy the journey of moot court. Post a question and speaker wants the researcher to clarify the question on behalf of them. Can this be allowed? Yes, definitely, yes. Zaina Fatima, yes. If the bench is allowing this, if the bench wants the researcher to answer a certain question, definitely yes. The researcher can stand up with respect, bow to the judges, and then answer the question posed by the. Definitely yes, you should answer it. Yes. Anything else? Okay. More specific things to add in compendium. Okay. The cases that you have used in your memorials, okay, that you want to present before the judges. Okay. The cases, very importantly, the cases. And you can even bifurcate. Cases can be one section, and then other research material in another section. And other research materials could be the annexures, I told you, some law commission report. It could be the past enactment. There is a particular provision that you want to bring to the knowledge of the bench. You highlighted something, you want to present it before the court, right? And it could be, it depends on each and every mood problem, I told you, there was one particular competition where we were talking about hydroelectricity power generation and how it was affecting the nature. There was a forest, and then that forest area was being destroyed, and that dam was being constructed. So we were explaining the negative sides of the dams, seismicity, the effect to the wildlife, the forests are being destroyed, and how this entire system works. What is a dam, and how the entire system works. So all these things, we had photographs of it. We had some various committee reports. The certain scientific committees were there, and their reports were there. We had added all those. In another mood board, we had collected information about health effects of abortion on a woman, and in one more we had done some research about you know other countries where possibly, there was some minimum education which was mandatory for the politicians. So like that, it depends on your mood problem. So you can even do some, I told you, it should be a thorough research. What the history of the legislation, the objects and the reasons. Why was this act enacted first in the first place? What was the previous legislation? Or if at all, say for example, the Nirbhaya case. After that, the criminal law amendment happened, right? So the law commission report could be added, and the Nirbhaya case could be, about that. If there is some important article that you want to add, that can be added. Okay, whatever you want to present before the bench, but make sure that it is not too bulky at the moment. The judges, because you hardly have what 15 minutes, and in the further rounds you have maybe half an hour. In that, you want the judges to concentrate on you and your arguments, rather than just get busy looking into some document somewhere. Okay, so I used to find convenient giving the material as and when I'm arguing a certain point. Okay, and by doing that, I'm diverting the judge's attention to that particular material only. When we have given a compendium, I used to find it inconvenient because they used to somehow start looking into the other pages, and they used to get distracted. So I used to avoid some moot courts. I have found it convenient to submit the compendium, and some places I felt, no, I will not go ahead with that. I will just submit the printed copies immediately when I'm arguing a certain point. Okay, so it depends on you. It depends on the strategy you're using for that particular mood and that particular round, that particular scenario. Have I answered it? Sure, Navya. Okay then. Thank you.
Ma'am, can you please share your LinkedIn profile?
Sure. I will share it with the organizers. Maybe they'll share it with you. Will that be okay?
Yes, ma'am.
Sure. Okay. Hello. Shambhavi?
Yes, ma'am. Thank you so much, ma'am. On behalf of Nyaya Shastra, I would like to extend our